Hey y'all, it's been a while since I have made one of these, and my throat is very hoarse, so hopefully you'll be able to hear me all right. For the evening, your topic is number 11. We are working, as we started last time, on the federal courts, and for your topic for this set of interesting notes, we're going to be talking about nomination, how do you get nominated, and then the decision process. How do the courts, in particular the Supreme Court, arrive at their decisions? So those are the two main topics. I just thought I'd throw that picture in there so you could see the current Supreme Court justices and their names, obviously, minus the gentleman, the second one from the left in the front row, Antonin Scalia. He is the justice who died, was it a week ago, roughly? So there are currently only 8. All right, so to serve as a federal court judge, what are the qualifications for office? You have to have certain qualifications to serve in Congress or to serve in the White House, certain age, you have to be a citizen this many years, that many years. What about to serve as a judge? Yeah, there's nothing. Basically, here's what it says. Article 3 of the Constitution says to serve as a federal judge, there are no qualifications listed, and your term of office is, quote, during good behavior, end quote. So, basically, unless you murder several people, you're going to have that position for life. Or, of course, in case you were to resign, or if you were impeached and removed from office, which has never once happened. You'll recall that constitutionally it's a 2-step process to become a federal court judge. The president will nominate, and then the Senate must confirm by majority vote. Checks and balances at work. So what's the nomination process like? Something that you're going to want to be familiar with in the nomination process, an important factor, is something called senatorial courtesy. So first we're going to start off here talking about regarding nomination as a district court judge or as an appeals court judge. We'll get to the Supreme Court later, but these two lower levels of the federal court system. If you want to get nominated, senatorial courtesy is an important thing. Here's exactly what that means. Senatorial courtesy, if you want to serve as a district court judge, it works like this. District court nominees will not get appointed. Pause for the announcement. Back from the announcement. District court nominees won't get appointed if they are opposed by a U.S. senator from the president's party in a state in which the nominee is to serve. So let's apply this. Supposing you wanted to run for district court. You live in Virginia. Let's say you wanted to serve on a district court here in Virginia. Well, supposing there was a Democratic senator from the president's party, President Obama, so that would be a Democratic senator from Virginia. That's the state in which you want to serve. And supposing that senator didn't like you, opposed you. What that means is this: the president's not going to nominate you. He's not even going to go there. Similarly, if you wanted to serve as an appeals court judge and you're a nominee, you're not going to get nominated in the first place if you're opposed by a senator from the president's party from the state in which the nominee lives. So let's say you lived in Virginia and you were known by one of the Virginia State Democratic senators, and they knew you. And the president came and said, so, Democratic senator from Virginia, what do you think about this nominee? The Democratic senator from Virginia said, bad news, that one. What does that mean? It means the president is never going to nominate you in the first place. This is a way of showing deference to the Senate in this process on the part of the president. Furthermore, sometimes when there's a judicial job opening, senators will actually go to the president and bring the president names of judges from their home states. So it's almost kind of flipping the process on the head. Sometimes it's almost like the senators are doing the nomination and the president is doing the approving. So all of this thing called senatorial courtesy, this is a great example of an informal type of check and balance. And because it exists, because it's such a powerful tradition, presidents usually run nominee ideas past the appropriate senators before they ever make any nominations. Now what about the Supreme Court? Nominations to the Supreme Court are critical because they're going to be there a lot longer than the president himself, as a general rule. So if you're president and you want a legacy, you want your policies to continue to be implemented, you want to have the opportunity to appoint Supreme Court justices. The president will rely on a group of people, White House aides, the Attorney General, and the Department of Justice as a whole, to provide a list of solid candidates. Just historically, there have been 153 Supreme Court nominees, and 112 have been confirmed. Now, of the ones that did not get confirmed, 29 of them actually failed. They were named by the president but did not get confirmed by the Senate. Most recently, you had Harriet Miers, who was nominated by President Bush in 2005, but was quickly withdrawn for various reasons. Robert Bork in 1986 actually went through days of Senate hearings, confirmation hearings, and then ultimately was not confirmed by the Senate. Recent judges, you don't need to know their names for the test, but it's not a bad thing to have heard of them. John Roberts was appointed by Bush in 2005. Samuel Alito appointed by Bush in 2006. President Obama's first appointment in 2009, Sonia Sotomayor, the first Latino woman on the court, and then Elena Kagan in 2010. There's Miss Kagan right there, in fact, at her confirmation hearings. What a lovely blue jacket. Now, historically, how difficult is it for nominees to the Supreme Court to get confirmed? Historically, it's been very easy. Very few have not been confirmed, as I was just pointing out a moment ago. But lately, though, within the last 10 to 20 years or so, as we've mentioned before, increasing political partisanship has impacted this process. So confirmation hearings are longer. Interest groups get more involved in supporting nominees that agree with their interest or opposing those who disagree. And more senators from the party opposing the president will work overtime to block his nominees via filibuster or via threatened filibuster. That's basically what the Republicans are threatening to do right now, as President Obama considers how to go about filling the position left by the death of Justice Scalia. So it's an increasingly partisan process, and so it's an increasingly lengthy and an increasingly hostile process, honestly. Now, in the situation that we're in right now, interestingly, the president does have the constitutional authority to do this. It's called make a recess appointment. That would be when there's a space, an opening on the court. A judge can be appointed without Senate confirmation, but that judge will only serve until the current end of the session of Congress. The sessions of Congress are 2 years long. So if President Obama appointed a recess appointment to the Supreme Court right now, he would only be serving for about a year until next January when the new Congress came in. Probably not going to happen. What is the process of court decisions? That chart, I think, will lay it out for you pretty nicely. Please notice there that requests for review of cases can come both from lower federal courts, district courts, appeals courts. But they can also come from state Supreme Courts, too. Sometimes the Supreme Court will take cases directly from state Supreme Courts. So as we said before, they will be asked to look at about 8,000 cases. There will be discussion about which ones to take. The rule of 4 will come into play, and then only about 100 or fewer will be placed on the docket for the year. So we're going to look at the process of court decisions. How do they arrive at their decisions? We're going to focus on the Supreme Court. And what are they looking for? Well, they're looking for cases that involve major constitutional or federal law issues. So civil liberties cases, things involving speech, religion, things like that, equal protection, or cases where lower courts have disagreed on how to interpret a federal law. So big issues like that. Now, key in this process of determining which cases to take is a person called the Solicitor General. This is the third ranking person in the Justice Department, and his or her job is to oversee all the litigation in the Court of Appeals, that second layer of the federal court system. So especially if there's a controversial case at the Court of Appeals level where the ruling actually went against the United States government, then the Solicitor General is likely to suggest it to the Supreme Court for consideration. And the Supreme Court will often listen. Pause for the announcement. All these announcements, and it's going on YouTube. You don't need to know this guy's name. but just in case you care, the current Solicitor General's name is Donald Verrilli. There he is. Nice tie, Donald. All right. The court meets every year from early October until sometime in June. It can be flexible depending on how long it's taking them to finish up their docket. They operate on a 2-week cycle, so basically they'll be in court hearing a case for about 2 weeks, and then they'll take about 2 weeks to reach their decisions. So before the case is heard, before they enter the courtroom, the justices, of course, will have reviewed briefs from the two litigants, the plaintiff and the defendant. They will have reviewed any and all amicus curiae briefs as well. In the courtroom, the two attorneys will have a half hour to summarize their case, and I do mean a half hour, like there's a light in the room. When there's 5 minutes left, a red light comes on to warn you. When your 30 minutes is up, you could be in the middle of a sentence. You're done. And during that time, while you're talking, attorney, the justices can listen. They can ask you questions. They're free to interrupt you. They can talk to one another while you're talking. They're free to do all of that. Then when that's over, they'll be back in the conference room. The justices will debate, with the Chief Justice acting as the chairperson, the moderator. So once a tentative vote is reached, once it becomes clear who's leaning which way or the other, opinions or statements of the legal reasoning behind the decision are going to be written up by any justices who wish to do so. There's 3 kinds of opinion. The first one is called the majority opinion, or more often called the opinion of the court. So it's reflecting what the majority of them think, the majority of the 9. If he's in the majority opinion will usually be written by the Chief Justice. If the Chief Justice is in the minority, then the longest serving, or the senior associate justice, will probably write the majority opinion. What if you agree with the majority opinion, but you have different reasons and you want to write them down so people know? Then you write what's called a concurring opinion. And then, of course, what if you're in the minority, you disagree with the opinion of the good court, and you want people to know why? Well, then you'd write a dissenting opinion. And this helps future generations to know what the justices were thinking when they rendered their decisions. It's important to have these records, as you'll see why in just a minute. So after the decisions are written, then a final vote is taken out of the 9. Now, for a case to even go forward, at least 6 justices have to be participating. Now, what if there's a tie? Supposing the court was hearing a case right now with Scalia having just died. It could be 4-4, right? If there's a tie for some reason, then the lower court ruling, whatever it was, is automatically upheld. There's no change. Now, in the vast majority of cases, the principle of stare decisis, I think that's how you pronounce it. That's Latin. It means let the decision stand. That principle will apply. Why? Because the judges want to defer to lower court decisions, lower court reasoning, unless there's a reason not to. In other words, judges have a great respect for what's called precedent, or rulings by previous courts. When they're making their decision, the first thing they look at is precedent. What have previous judges, previous courts thought about cases of this type on this issue? Sometimes people want to know, can the Supreme Court overrule itself? Yeah, reversing prior decisions does happen. When we get to the next unit on civil rights and liberties, you'll see several examples. Now, on what basis do judges make their decisions? As I just said a minute ago, they will begin by looking at precedent, prior court decisions on that topic. All right, what if precedent isn't clear, or what if there isn't one? How do they make their decisions? Well, at the end of the day, it comes down to judicial philosophy. Choice number 1 is originalism, trying to interpret the Constitution or the law in a way that's consistent with what the authors meant, or what a reasonable person living at the time of its passage would have understood the meaning of the law to be. That would have been Justice Scalia, Justice Thomas. Others believe in what's called the living Constitution view, the idea that the Constitution and our laws are open to differing interpretations and will always be guided by current understandings. Very different judicial philosophies. What you want to look at here, since I'm almost out of time, is what happens after the Supreme Court hands down its decisions. And the answer is nothing, unless Congress and the President decide to do something about it. Judicial implementation, how and whether court decisions are translated into actual policy, is up to the other 2 branches. The court has no enforcement power.